Welcome to For Better or For Court, Family Law in New Jersey.
Welcome back to For Better or For Court, Family Law in New Jersey with Ms. Alix Claps. Alix is a partner at Heymann and Fletcher and a certified matrimonial law attorney who helps New Jersey families handle divorce, custody, and complex family matters with clarity and care. I'm Evan Mack, and today we're talking about retirement accounts. Alix will go over how they're divided in New Jersey, divorce, and why something called a QDRO can make or break that process. My dear Alix, welcome back.
Hey, Evan, how are you?
I'm well. So, Alix, are retirement accounts always considered marital property in New Jersey?
See, you said that red flag word, always. There's no always. I'll say that retirement accounts to which contribution was made during the marriage are considered marital property. So if I had a job when I was 18 and I had a retirement account from that, and I didn't add anything to that during the marriage, that's going to be exempt because I didn't do anything. The marriage didn't contribute to the growth of that account. The stock market did. So that's going to be exempt. If I have one that I started before the marriage and I continued to add to through my employment during the marriage, the portion that I added during the marriage and its growth is going to be dividable, but everything I contributed before the marriage and all of that growth is going to be exempt. Same with anything I added after the date of the complaint for divorce or whatever we've decided the end date of the marriage is. So there's a presumption about portions of a retirement account being a marital asset, but sometimes teasing out what is and isn't marital is the most complicated part of a retirement asset.
How does the court distinguish between the portion of retirement, account that is marital versus premarital, though?
Well, sometimes they rely on experts. If there's a dispute about that, if that's something that's going to be determined at trial, you're going to want to get a forensic accountant to determine what portion was premarital, what the value of that was as of the date of the marriage, and what the value of it is as of the date of the trial, because it's a moving target. That number is going to continue to change almost every day. So you've got to give the court something. So don't make the court do math. Give the court the math whenever possible, because they're going to want to decide the facts, but they're not going to want to have to come up with the facts. They've got to make a decision about which one of you is right, or do I think your two experts are $10,000 apart? Do I think the right number is exactly in the middle? Is it more on one side? Is it more on the other side? Let the judge give the judge some information to work with.
What exactly is a QDRO, and why is it required in many divorce cases involving retirement assets?
So a QDRO stands for Qualified Domestic Relations Order, and it's required for certain retirement accounts, usually 401ks or pension accounts, and that has to do with the way that they interact with federal law. So a Qualified Domestic Relations Order allows you to subdivide what is essentially a pre-tax asset, so something you're contributing to on a pre-tax basis, without incurring penalties or fees or taxes for going into it before you reach the minimum retirement age for it. So that the order is very important. Otherwise, you're going to get into trouble that you don't need.
Are all retirement accounts divided using a QDRO, or does it depend on the type of account?
It depends on the type of account. A 401k requires a QDRO. A pension requires a QDRO. Often an IRA does not require a QDRO. It requires what's called a letter of instruction, which is a little less formal. So you tell and some of them have their own forms. If you have an IRA through a financial advisor, they might have a specific distribution attendant to divorce or following the entry of divorce, something like that. They're going to want you to fill out their paperwork and hand it in. Covers their butt, covers your butt, but it's less expensive than having a full QDRO prepared.
What can go wrong if a QDRO is not drafted properly or not submitted in a timely manner, Alix?
There's two buckets of what can go wrong. The first is malfeasance, where if you don't do it and your spouse decides, you know what, I don't really want this person to have my retirement account, I'm going to take it and hide it somewhere else when they're not supposed to. And they know they're not supposed to, and they do that. Or they get in a desperate financial situation and they tap into it on an emergency basis. Even if they only tap into what's their portion of it, they've now created a complication that didn't exist before. There's also the no malfeasance, but something else happens. So I had a case recently where while the QDRO was with the court, we were waiting for the court to sign the order, the plan changed hands. So suddenly the new plan couldn't do the plan administration of the distribution of the old plan, and we had to update the QDRO and give them much more specific information when the old plan could have done what they were supposed to do had the court gotten back to us in less than 6 months.
when in the divorce process should the QDRO be prepared, during the settlement negotiations or maybe after that judgment is entered?
Most times QDROs are prepared after the divorce is finalized. One reason for that is that's when you've agreed on everything. So you know exactly how you're treating the retirement accounts. Another reason is most of them require a copy of the certified judgment of divorce, and the pages of the executed marital settlement agreement that tell them what they need to do with the asset. There are cases where people agree that they're going to use a retirement asset for something during the pendency of the divorce, like a litigation fund, where they might need to do a qualified domestic relations order to divide the fund earlier. That can happen, but that is rarer.
How are the pensions valued in New Jersey divorce cases, especially when you will not be paid out for many, many years?
All right, I'm going to say this from the lawyer perspective, because I am not I go to a financial expert to start with when I need a pension valued. And again, not all pensions require a valuation. Often I'll do a pension valuation when we're thinking about doing an offset for the value of the pension or a buyout for the value of the pension rather than dividing the pension, which doesn't require a valuation. But if I need to know what the pension is going to be worth to my client at the time when it would be distributed, I need a forensic accountant to go in and they use the historical contributions, the estimated monthly amount that's going to be given out as of the estimated date of retirement. They use actuarial tables to try and determine how long the pension is going to be paid out for, because most pensions terminate when the employee dies. There's no survivor benefit or something like that for my client. Assuming my client's not the employee, my client's the spouse. When the other party dies, it ends whether my client's dead or not. And that's one reason why people do a buyout of a pension or an offset in some other way, because the pension can end in a way that a 401k doesn't end.
Can one spouse offset a retirement account by giving up another asset like equity in the home and, instead of just dividing it?
Absolutely. A lot of people, particularly those with pensions, want to keep their pension. That's the retirement account that I think gets horse traded the most, but it can be for other retirement assets. It could be for an increase in the amount of alimony paid prior to retirement. You can offset it in a million ways if you settle. If you go to trial, the court will not offset the pension. They're going to divide it in accordance with the law because they don't really have a choice in that matter. They don't get to get creative. So it's another reason why settling your case allows you to make decisions that are right for you.
How do taxes factor into dividing retirement accounts? Are people sometimes surprised by the future tax consequences they might incur?
When I talk to my clients, I make sure I explain that the reason why we need a qualified domestic relations order is so that it remains a retirement account, even though it's being divided now. So if people think, oh, well, we're dividing the 401k now, I can just pull the money out, then they're going to have tax consequences that they may not have thought about, early withdrawal penalties and the immediate tax consequences. And if you pull out too much, you're going to bump yourself into a new tax bracket sometimes. If you wait, then it gets treated as regular income at the time that you hit the appropriate retirement age for the plan. So it's important to generally go over that. And again, I always advise my clients, talk to a tax expert or a financial advisor if you don't have a firm grasp on what your assets do, what their format is, or how they function in your life.
If someone discovers years later that a retirement account, was never properly divided, is there any, legal remedy available?
Yes. Although how that remedy works, again, depends on the status at the time. So if the retirement account has changed plans, sometimes we can't go back and get all of the records. So it might be that we need a financial expert or a forensic evaluator to sort of recreate or make an educated deduction as to what the value would be now based on the information they have about how that plan behaved, how the market behaved, things like that. Or it maybe make more sense that, all right, let's say that this 401k wasn't divided, it's gone now. What other options are there? Is there something else that we can get in exchange for the value of that? It doesn't have to, money is fungible. So while retirement assets are treated distinctly from other assets because of the way that they behave in terms of tax liability and the restrictions on access to it at certain stages of your life, money is fungible. So if you're at a stage in your life where you'd be tapping into that retirement account anyway, and you wouldn't be expecting it to continue to grow, you have a little bit more flexibility, although who knows what you have to go after at that point.
So for anyone going through that divorce now, what is the most important thing they should understand about protecting their share of the retirement assets?
Do the QDRO as soon as possible, because it's not necessarily that anybody has any ill intention, but you know what it's worth at the time of the divorce. And after that, you have no control over it, and things can happen that make it difficult and more expensive down the line. So if you've reached an agreement, I know once you get divorced, you just want to be done, but do all of the T crossing and the I dotting. And that includes paying the money to get the QDRO as soon as possible.
Miss Alix, thank you so much.
Thank you, Evan.
That's a wrap on today's episode on For Better or For Court. If you have questions about dividing retirement accounts or want to make sure your financial future is properly protected in New Jersey divorce, visit HeymanFletcherLaw.com to connect with Alix Claps. Be sure to like, leave a review, and share this episode with someone who might need it. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.